welcome to today's webinar. This is going to be an interesting and scary one. Network security and privacy breaches. Hackers are just the tip of the iceberg, brought to you in partnership with Chubb. I'm Dave Nelson. I'm a 9-year Vistage member, and we're very fortunate today to have two experts on the line with us, Ken Goldstein from Chubb Insurance and Brian Lapidus from Kroll Advisory Solutions. Let me give you a little bit of a background on each of these guys. Brian Lapidus is Senior Vice President of the Information Security Practice at Kroll Advisory Solutions. They're a global leader in risk mitigation and response that delivers a wide range of solutions that span investigations, due diligence, compliance, cyber security, and physical security. Brian brings 15 years of leadership to the guidance of partner relationships and the strategic development and execution of Kroll's growth initiatives. Currently, Brian's team is charged with providing companies with Kroll's end-to-end incident response and information security services. Ken Goldstein is an attorney and the worldwide media liability manager and cyber liability expert for Chubb. He's responsible for Chubb's news media, multimedia, video and film, internet, and new media business. He's previously worked as a claims attorney and in several legal firms. They're both going to talk today, but Brian, why don't you get us started?
Great. Thanks a lot, Dave. Really appreciate the introduction. To get us going, I really want to quickly hit the agenda for the conversation today. Ken and I are going to cover some statistics and trends associated with data breaches and privacy losses. We're going to explore the evolving legal and regulatory climate impacting businesses today. We're going to look at the critical components of data breach, of creating a data breach incident response plan. And then we're going to look at ways to transfer risk associated with cyber breaches and what questions to ask your in-house insurance buyer to help protect your company. Now, Ken and I do some work together, and so sometimes we may look at topics a little bit differently. So if things go right, you may actually get some debate between the two of us, which is always a lot of fun for our audience. With that, Ken, next slide, please. When we do these events, I always like to set the stage with a glossary. I think setting the language for the discussion around data breach and data security is really important. So with that in mind, I want to draw your attention to what I think the most important word that we're going to talk about today, and that word is breach. Now, from our perspective, this is the definition. It's unauthorized acquisition, access, use, or disclosure of confidential information which compromises the security or privacy of such information. So when we talk about a data breach, this is what we're talking about. Two more terms that I want to make sure that you're aware of, because we both reference them a lot. One is called PI, or initials are PII, or personally identifiable information, which constitutes name, social security number, date of birth, or PHI, protected health information. Now, with these definitions and this language in place, now let's begin the presentation in earnest. Next slide, please. So what you see here is what I will call, it's the key costs of a data breach. And when people think about what the costs are, you got to break it down into the right categories. So I'm going to go through them now. Based on the 2010 study, the cost per record lost for an organization is around $214. Now that constitutes direct costs, which is at around $13, which includes data forensics. So when a data loss event happens, understanding what data was actually lost, running the discovery on your systems, as well as doing consulting services around getting a feel for how it happened and what happened. So that's the $13 per victim. The next one is, per record. The next one is victim costs, and that's at $15 per victim, and that includes notification, call center, so making sure that you have trained professionals there to answer questions regarding the event that's happened. Some sort of identity monitoring, so credit monitoring, someone to monitor the credit accounts of the individuals whose data was compromised, or what we call non-credit monitoring, which is the market's less familiar with, but it's monitoring public data records of individuals which may be compromised based on the data breach. And finally, identity theft restoration services, and this is one of the things that Kroll specializes in, is providing restoration services back to consumers so that consumers who are victims of identity theft don't actually have to do any of the work of resolving the issues. Companies, organizations such as Kroll will do it for you. The next piece are indirect costs, which includes restitution, additional security audit requirements, lawsuits, regulatory fines. That's $51 a record. I recently read a study that there was around an 11-year hangover to a data breach. So an organization that has a data breach is paying for audit requirements, security requirements, legal fees for an incremental 11 years after the event. And finally, what can't be minimized is the opportunity cost, around $135. This cost could be due to loss of consumer confidence, loss of funding. We've seen, especially in particular in the healthcare space, that the loss of consumer confidence and what we'll call the patient churn, so patients going to different healthcare organizations after an event, are significant and a significant cost to the organization. Now, we saw a drop in the per-free records in 2012 in the 2012 Poneman study, which reduced the cost from $214 to $194 per record. One point that I think is worth noting here is that there was a change in methodology between the two studies, where breaches of a higher number of records, that record of 150,000 records looked at was reduced to 100,000, and I think it's that differential that actually drives the decrease in cost per record, not an actual reduction in cost. So if you're familiar with the studies, we just wanted to clarify that data point for you. Next slide, please. You know, I look at this slide, and when we present it, I think of this as the, people escaping the prison wall. Data can escape your organization in many, many, many different ways. So this slide talks about all the different ways that it goes out, but I want to focus on 3 today as we look at this. The first one is email. Often, and unfortunately, we see individuals just make mistakes, right? That's human nature. We see them email information, email PII or PHI out of the organization by accident, in error. They're sending a file of all the employee benefits, and they by accident send it to the wrong person. These sort of accidents happen, and they account for about 4% of the data escape from an organization. The next one that I'd like to talk about is what I call it fraud social engineering. So this is a type of fraud that uses email, websites, pop-up messages, text messages, or phone calls to misrepresent a company in an attempt to trick someone into sharing confidential information. So a couple examples. Sometimes I've gotten this personally. You get an email to your personal account, and it looks like your bank. It feels like your bank. It's in the right colors. The email address still looks like it comes from your bank. But really, this is a phishing email. This is someone trying to get you to disclose information that you would only disclose to your bank. So that's called phishing. I've seen those come to our clients via voicemail as well. Someone calls and asks for that information over the phone. And my favorite, just because I like the word, is smishing. It's SMS, ISHING. It's use of text messages to get that same information. So that fraud social engineering is a big way that people try to get information out of organizations. And finally, the largest one is theft. There are malicious people out there who want to get your data, and they do it in a way that where they are targeting your organization, and they access the data and steal it for their own gain. Now, as it relates to data breach causes, there's a lot of media coverage and industry commentary on the causes of data breach. How did it happen? That's the question that everybody asks. And here I tend to think that the media in particular likes to focus on the sexier issues that cause data breach, like hacking, which is understandable given the cool names and dramatic impact that some of these external vectors have. But as the title of this presentation suggests, hackers are just the tip of the iceberg when it comes to data breach causes. The best way to look at your risk issues is to divide them into internal and external threats. Now, don't get me wrong, external threats are indeed very scary and worthy of the attention. But the fact of the matter is, and what I'll be showing you over the next few slides, is that internal threats may be a little bit more mundane, but they are significant because, quite frankly, they are just as prevalent, and more importantly, they are the ones that are easiest to mitigate, so the ones that really you should focus on today. Organizations need to be aware of both to put their best foot forward in reducing the associated risk. Ken, next slide. So I love doing this, and I actually like doing this when sort of we're all in a room together, so we'll try it virtually. But I like looking at the differences between the myth versus the fact as it relates to an insider threat. Now, in some ways, the purpose of this presentation is really to level set your ideas and perceptions about what you should be focusing on in terms of data security, because there's a lot of misconceptions out there. One of the things that, this discrepancy, as I said earlier, is really, really interesting, especially when we're in person. So let's just try it virtually. Myth number one, the majority of internal data breaches are intentional. Now, the truth here is that it's not that your employees are out to get you, and malicious intent is not the cause of the majority of insider breaches. In fact, more than 85% of internal breaches are the result of negligence, such as improper disposal of data, or lost laptops, or lost mobile phones. Of the insider breaches that are publicly reported, those executed with malicious intent compromise only 15%. The source of this data is the Privacy Rights Clearinghouse. The next myth, insider threats are limited to an organization's employees. The truth here is that insider threats also comprise contract workers, temps, employees working for third-party vendors. In fact, in Kroll's own recent survey in the healthcare market, 34% of respondents indicated their breach was a result of actions taken by either a third party or a contractor. Finally, the last myth I want to cover is that internal incidents are easier to resolve than external cyber attacks. Now, the truth here is that malicious insider attacks take more time to resolve, on average 45 and a half days longer than other institutes in this data, other sort of non-malicious attacks. And this is according to Ponemans Institute's second annual cost of a cybercrime study. Next slide. So I mentioned mobile devices earlier in terms of a cause of a loss, of losing data. And if the majority of internal breaches are the result of negligence, then let's say that a lot of lost laptops and other mobile devices are a consistent source of data breaches for businesses. While it's important to protect against cyber threats, lost and stolen devices, mostly laptops, but now increasingly smartphones, remain one of the top threats to data security. Our own analysis of the information reported to the U.S. Department of Health and Human Services for breaches impacting over 500 patients reveals that nearly 51% of breaches were due to lost or stolen desktop computers, laptops, and portable electronic devices. So when you think of lost hardware, that's not necessarily just a stolen loss to your organization. You've got to think about what was on those devices. Ponemans' cost of a data breach report consistently shows breaches attributed to a loss of a mobile device at roughly 35% across all industries. Now, I think these statistics justify the expense of encryption and other security features for mobile devices. One of the other things to think about is regarding your policies and procedures as it relates to mobile devices in the office. With most mobile devices serving as mini computers, you need to understand how they're used in your office. A couple examples. Now, if an employee is allowed to plug their non-standard mobile phone into their machine at the office to charge, to get power, you need to make sure that their personal devices are not able to access corporate data or corporate PII. Because if they did that and that data went on their phone and they lost their phone, that would be a data breach. One other thing to think about is that given that you mostly now have, everyone has a camera on their phone, or most people do, often picture taking in the office using a mobile device doesn't make sense. We recently had a client whose employee took a picture of a colleague in the background, but in the back of that picture was a spreadsheet that had lots of medical information on it. they posted this picture on Facebook. Someone saw it, zoomed in on the picture, saw the PII, and all of a sudden you have a data breach. So things to think about, making as it relates to your mobile phones, how you deal with data from these mobile phones and pictures really need to be part of your security policies and procedures. Next slide, please. APTs, Advanced Persistent Threats. Now, even if you have never heard of these, it's a perfect example of why hacking is such a huge fear factor for a lot of companies, because it combines all the security worries that keep your CIO and your IT department up at night. So let me define what an advanced persistent threat is. These are a category of cyber crimes that are predicated on getting in early and staying in for a long duration to continue to extract meaningful data over a long duration. When I talk about advanced persistent threats, I think I use the words low and slow. A couple of examples. You have a rootkit that infiltrates your network and lies dormant on your system. However, it's programmed to capture and export all credit card data that comes through your network. So this rootkit gets in your network, it's sitting there, but when it sees credit card information, like a number on an American Express card, it becomes active, it pulls the data, and then it exports it out of your network. If you're not looking for this type of a rootkit, it could just exist on your network in perpetuity. Not a good thing that you want to have happen. So that's a technology-based advanced persistent threat. We also have what I call the human advanced persistent threat, and that's someone who comes to work for your organization with the intent of capturing PII or PHI and selling it on the black market. So all of a sudden you hire an employee, they're sitting in HR, they're running recruiting, so every applicant who applies for your organization's data is being compromised and sold to the black market. Now, most of the time when you talk about an advanced persistent threat, it is more technology-based, but I think it's that same mentality from a human capital perspective. It's that low and slow. You've got someone in there who's doing it, they're doing their job, but they also have a malicious intent and are capturing data as they need it. I think the interesting thing is that by and large, attackers' favorite way of gaining entrance into your system is to take advantage of an internal weakness. So documented instances of phishing emails that we've talked about, as well as using USB devices left in the parking lot that employees can get plugged in to your computers, are easy ways that attackers can access your network. You've got to train your employees to think like a risk manager, because the more often that they're aware of security risks and can follow best practices as it relates to protecting your organization, the better. This new trend of using employees and using the natural vulnerabilities in your network are a large cause of data breach that we've seen right now. Next slide, please. So now that we've gone over the brand new as well as the tried and true, I'd like to close out this section by circling back and sharing one more statistic with you. This one comes directly from Kroll, from our global fraud report. I think it's interesting because it's based on our senior executive worldwide survey, where we surveyed 1,200 executives across the globe. It really shows just how universal the battle against information has become. Nearly 23% of our respondents indicated that their organization has experienced information theft. 16.7% lost customer PII, 11.9% lost PII, employee PII, and 20% lost proprietary data or intellectual property. The loss of data is an incredibly expensive proposition for organizations like yours, and one that you need to be mindful of. Ken?
Great. Thanks, Brian. Appreciate the overview on statistics and trends. Really, the second section of our discussion is going to focus now on the regulatory landscape and evaluating cybersecurity exposures, both from a general perspective as well as from a legal perspective as well. I thought that the best place to start was really the state lens before we worked over to the federal side. There are actually 46 different states across the country, plus Puerto Rico, Washington, D.C., and the Virgin Islands that actually have breach notice requirements, which in essence means that if your employee or customer information happens to be compromised from a breach perspective, the PII or the PHI that Brian was talking about, you've got an obligation to notify those employees and or customers about the breach. And this actually turns not so much on where your company is located, but it's actually where the employee or customer is located. And to the extent that you're doing business virtually, that could put you at risk from a breach notice requirement standpoint at the 46 states plus a variety of the other areas there. And in addition to actually having to provide notification to the individuals who have the ability to be impacted, actually have to notify in certain instances other places as well. So perhaps the state attorney general, and if you're involved with multiple states, then there may be more than one attorney general involved in that notification type of process. Could be a consumer protection agency all the way through a credit monitoring agency. And what does that bring into the forefront? That brings to the forefront the possibility of having an enforcement action that an attorney general could be looking to pursue against your company, which means the possibility of defense costs, which means the possibility of fines and penalties. And on the monitoring side, what's standard in connection with the notification and perhaps call center perspective Brian alluded to earlier has to do with the possibility of monitoring identity, monitoring credit, all the way through the possibility of offering some type of restoration services as well. Now, if the regulatory stuff doesn't scare you enough, you have the potential for people to bring suit in certain instances to the extent that these states actually allow it, and not all of the states allow it, but a number do. And you might be asking yourself, okay, we've got 46 states plus other areas, plus perhaps federal and perhaps international. Why doesn't the federal government perhaps step in and do something so that we have a specific standard that we understand how to apply on an across-the-board basis? And if you look at what's going on the Hill, there's a variety of pieces of pending legislation going on. There's a couple that seem to be on point with regard to rationalizing these 46 states and putting it into a single standard. The first of which is the Data Security and Breach Notification Act of 2011, Senators Pryor and Rockefeller. The other has to do with the Data Breach Notification Act of 2011 with Senator Feinstein. So let's hope that they get something passed, make it easier for all the companies that are subject to these types of criteria. Now, unlike the state perspective, there are specific federal nuances in place that don't address the 46 states, but address specific segments. So, for example, if you're in the banking industry, Gramm-Leach-Bliley has expectations that you're going to have some type of a written information security program in place. Why? Because it's going to protect your customers' information from a financial and perhaps Social Security information and other information perspective. In addition to Gramm-Leach, you've got FACTA, Red Flags program, which essentially applies to creditors as it respects them interacting with debtors. Same type of context in terms of having some type of a written plan in place, this time really to gear against identity theft, having basically reasonable policies and procedures in place, not only to detect issues associated with identity theft, but also preventing and mitigating identity theft as well. And then, of course, you may have heard a lot about HIPAA and high tech. If you're a healthcare provider, if you're a healthcare clearinghouse, if you happen to be associated with a healthcare plan specifically from an organizational perspective, you've got things set up where if you compromise PHI along with names, you've got the possibility of state attorney generals going after you and the possibility of significant fines being levied against your company. And this can happen not only from your own perspective, but the business associates actually that you partner with as well that can generate a similar type of exposure. Now let's talk about things really beyond the context of regulatory oversight. And let's talk about really cybersecurity exposures really from a general perspective. What I want you to be able to do is I want you to be able to visualize a couple of different buckets. Off to the left, create a bucket with the category of network security and privacy. Off to the right, I want you to create another bucket with a content liability topic in mind as well. And then we're going to talk about really what goes within each bucket, kind of how you fill it up. So from a network security and privacy perspective, there are actually components that are known as third-party liability components in terms of exposures, and first-party expense exposures as well. Well, what does that mean? Third-party liability exposures, essentially claims that could be brought by individuals against your organization because of the compromise of their PII or PHI, or perhaps those claims will be brought by your business partner organizations because you've somehow put into play their business and proprietary information that you actually have in your care, custody, and control. You may have third-party liability exposures associated with virus attacks that are actually transmitted from your system to some type of a customer system, and then it'll actually generate some type of a suit there as well. Or you may have some type of an impaired access issue where your site's been attacked, it's down, and somebody who's supposed to be able to get into it in order to conduct business can't. and they're going to pass along a business interruption type of claim against your company as well. So those are really third-party liability, network security, and privacy exposures. How about from a first-party expense perspective in terms of the bucket that I talked about? These are expenses that your company is ultimately going to have, irrespective of whether you actually get that third-party suit from the individual or organization. It might touch upon things like forensic investigation, all the way through the cost to notify and monitor or provide restoration services, things like that. And I'm actually going to touch upon this in a little bit more detail in the next slide. So let's actually flip over to the other bucket that I mentioned, and that has to do with content liability. Ask yourself at this point, what company doesn't have internet presence? What company perhaps hasn't decided to market their products and services via some type of a dedicated Facebook type of account, or perhaps a Twitter type of feed, or blogging generally? What I like to tell people is that these companies, which aren't traditional media companies, they effectively take on the same liability exposures as media companies do, which puts into play defamation from a reputational standpoint, or trade libel, which essentially is defamation or disparagement between companies. Could be disclosure of private information. It could be misappropriating somebody's name and likeness in connection with a campaign that you're running without consent for commercial purposes. Might end up being some type of theft of original works of authorship, copyright infringement. Maybe it's content in a video that you put up and you didn't have permission for the music that went along with your campaign. Could be trademark and service mark issues. That name, that word, that symbol that you use to identify your services or your products, to distinguish them from your competitors. Maybe it's just too similar to something else that's out there in the market already. Now, what I want you to think about next is a different way about assessing the exposures. I want you to think about it from the perspective of the third-party liability. I want to talk a little bit further about breach, and I'll talk very briefly about cost of correction within the context of content liability. Legal exposures. To the extent that you're going to get sued by individuals or organizations, you've got a variety of exposures that you're ultimately dealing with. You can have a scenario where you're sued. You have to get outside counsel, which means you're going to incur defense costs. That type of a suit or an enforcement action may not come from an individual or organization. It may come from a regulator, which means you're going to have regulatory defense costs that you're going to incur. You might have some type of payment that you actually have to make after you're sued. You may settle that claim. You may get a judgment against you. Maybe it's the person whose PII was compromised and was used in a way that harmed them that you're actually going to end up paying damages for. What if it's more significant than that? What if it's actually a class-wide basis? And that number obviously is much more significant. You could just look back to the issues associated with what Brian referred to before from the Poneman Institute study. And then you obviously have the issue associated with regulatory fines and penalties. These consumer redress funds that are set up to really protect the public whose information was compromised. All different types of legal exposures, more third-party liability oriented. How about on the breach side? I mentioned in the network security and privacy kind of bucket analogy that there are first-party expenses, the expenses that the company is going to have, irrespective of whether they're sued. And typically where things start is really on the forensic side. So you're going to have some type of a forensic team come in. They're going to conduct an investigation. They're going to analyze what in fact has been taken. Well, why are they going to do that? Because then they're going to bring in independent counsel, and that independent counsel is going to look at the information that was taken and figure out, is it the private type of information that actually those 46 states plus the other federal regulatory issues involve, such that you're actually going to have to notify individuals about, perhaps provide monitoring about, or restoration services. And keep in mind, the $214 per record that Brian touched upon before, a big chunk of that had to do with your existing customers perhaps not staying with you anymore, or perhaps future customers not wanting to associate themselves with your company, which brings in expenses or exposures associated with really public relations, kind of managing the expectations of your client roster or future potential clients. Other first-party expenses. If you're attacked and you're down, especially during a critical time, you may actually lose business income. You may incur extra expenses that you wouldn't have to have had incurred but for the attack. That's where business interruption and extra expense exposures come into the forefront. We've even seen attacks levied against very big companies that have suggested that they've had access to their employees or customers' PII or PHI, and they're not going to back out of that system unless, of course, they get paid a ransom. So you've got exposures to ransom payments. And if you're going to have exposure to a ransom payment, you're going to need some type of firm to come in and help you negotiate through that scenario as well. Cyber extortion essentially is what it's referred to as. Last exposure is really more specific to content. As you think through the campaigns that you run online, think about a scenario where your content went out and there was something wrong with the content, and instead of waiting for the suits that would happen as a result of the content not being fixed, you're actually having to pull back your advertising and all the money that you spent on it and correct it and the expenses associated with that. That's essentially in the media space what we like to refer to as first-party cost of correction. Let's look at things beyond the general exposure perspective, and let's look at what's been going on from a legal perspective. And from a legal perspective, there are definitely eroding legal defenses, meaning it's easier for folks to get access to court and litigate against your companies. The first case that I have up here on the slide, Stallenwork versus TriWest, is an example of theft of PHI. And in that instance, the plaintiff, in addition to demonstrating liability, meaning the company failed to protect the PHI in the first instance, they actually had identity theft, so they could actually recover. That's the type of damages that you would think somebody would actually have to show in order to sue. But the next three cases are much more worrisome. Krotner versus Starbucks is a case out on the West Coast, involved the theft of laptop and Social Security information. And the court, early on, allowed the plaintiffs to litigate the case. They gave them standing. They gave them access to court. They gave them perhaps access to discovery. And quite frankly, at the end of the case, the plaintiffs weren't able to demonstrate that anything happened with their information. They weren't able to demonstrate damages. Their case was dismissed. So what was the exposure in that case? The defense expenses that the company had. And they could be significant. Third scenario, you have a publicly available type of breach scenario involving a company by the name of ChoicePoint. They ended up getting involved in a very large settlement with the FTC. They were selling off consumer information with private information attached to it. And ultimately what was interesting about this specific settlement is they had suggested, meaning the FTC, that if people spend time monitoring their own identity or credit or whatever the issue is associated with a particular breach, or just the general time that they spend responding to the breach, that could equate to money, that can end up in a consumer redress fund, and again, this was like a high 7, low 8-figure type of resolution, so fairly significant. And if that doesn't make it as exciting as it could be, you've got cases like Clayridge versus RockU, which involve online user ID and passwords of online gamers that were compromised. And you think, okay, user ID and password information. I didn't see that on the list that Brian started out with. Well, this is a specific court that decided that user ID and password information would be considered PII. It's private information. Why? Perhaps they're concerned about phishing with the PH on the back end that you heard about from Brian. People getting things that look like they're legitimate, but in fact they're coming after the online gamers in a different way to get access to their system. And this court went further and they suggested that this type of PII has an ascertainable but unidentified value associated with it. Scary types of things. What we're going to do now is I'm actually going to transition back to Brian. You've heard a little bit about the stats and the trends. You've heard a little bit about the regulatory and overall cyber type of exposures. He's going to talk a little bit about preventative planning right now along with incident response components. Brian.
Great. Thanks, Ken. And I'm going to move through this a little bit quickly. I know we're starting to run a little short on time, so I'm going to move through this a little bit faster than I did the first section. To begin with, I would recommend you start your planning with 2 questions. First one, does my team know what to do if we have a data security event? But 2, and I think this one might even be more important, does my team know what not to do? Let me give you some examples. Do your employees know what a phishing email is, and can they tell the difference between a phishing email and a normal email? Right? If they know the answers to those questions, they're going to be able to help reduce the risk of an intrusion in your business. Do your employees know not to plug an unknown USB key into their computer without first understanding the original ownership? Those kinds of questions, making sure that they know what not to do, makes preventative planning that much easier. So the more you can get your team aware of what they shouldn't do is a great best practice to help reduce the risk. Next slide, please. Now, as an organization, it's critical that you have a plan in place should you have a data loss event. Part of that plan requires preventative planning and allows you to think about and test areas of your organization so that you're better prepared. Best practices, here are some examples. 1, performing a vulnerability assessment to determine the efficacy of the organization's security posture and determining weaknesses. It's a terrific first step. You understand where the weak parts of your network are, and then you can plan accordingly. Next, review organizational policies and procedures and modify them to ensure that they're up to date and address new trends. So as an example earlier, I talked about mobile devices. A lot of policies and procedures don't think about mobile devices, don't take into account the fact that an iPhone is a computer, and that plugging that into your network, may open up some vulnerabilities for you. Making sure that those policies are up to date at least gives everyone in your organization a standard by which they're expected to behave. Third, and I sound like a broken record on this one, but I think it's important. How have you trained your employees to help mitigate the risk? Ensuring that your employees know what to do, how to do it, and what to be aware of is a tremendous way for you to prevent these events from happening within your organization. Finally, make sure you know what resources and vendors you would need if you have an event. Having contracts renegotiated and relationships already in place make life when an event happens so much easier. Think of it as registering at a hospital before you go into labor. It makes the arrival at the hospital a whole lot easier, and you can just get on with the business of giving birth as opposed to dealing with all of the paperwork. Next slide, please. One of the things that we want people to think about when they have a data breach is we want them to be in the absolute most defensible position that they can be in. Now, we help organizations manage these data breach events every day, and I can tell you that no two events are ever the same. The key here is how organizations actually deal with the event. It's the handling of the event which separates the professional organization from those who flounder and often fail, both from a compliance perspective as well as in the court of public opinion. Now, over the next few slides, I'm going to share some best practices which should help you plan for these events that may happen in your future. First, test your IRP. An IRP is an incident response plan. But if you have this plan and you've never tested it or updated it, it's a waste. It's a waste of shelf space. It's a waste of a document on your network. You've got to make sure that the guide is up to date, it's used, it's tested, and the people in your organization know how to use it. It is a critical, critical, critical tool for you to have. Next, ensure that the key players understand their roles and ultimately who's the final decision maker, right? If your organization knows how to handle a crisis, you know who is talking to the media. You know who's responsible for dealing with any vendors that you're dealing with. They know who's dealing with their customers. The organization has a rhythm about it for who does what when. And making sure that those players know who they are and what they do is critical. Now, we always recommend when these events happen to run an investigation. Understand what happened. Understand what data was in fact compromised, and then use that data and that investigation to make the right decisions. So I'll give you a quick anecdote. We were working with an organization. They thought they had lost 200,000 of their customers' PII. It was their historical customer database. Now, we ran an investigation to understand exactly what happened. During that investigation, we found that only 20,000 of the 200,000 customers' data was exposed. So that organization only had to notify 20,000 people as opposed to 200,000 people. The investigation drove the decisions of that organization. If they would have never done that investigation, they would have notified all 200,000, and I will assure you that if you go think back to the beginning slides, the cost of notifying 20,000 records versus 200,000 records is significant. I think part of also planning in this equation drives confidence in how your organization is perceived. I've seen many organizations turn these bad events into a positive one. So restoring communication is really, really key, both internally for your staff, if there's been an issue internally, as well as externally. What are the things that you're doing to handle the security issue around what happened? What are the things you're telling your customers that are going to make them feel better about giving you your data again? How are we going to resolve? Giving them a feeling that you're actively managing the situation goes a long way in the court of public opinion and with your employees. I think finally, following this, make sure that your post-event plans, that you're learning from these mistakes. Unfortunately, these events are they happen often, but and they sometimes happen repetitively. But let's put it this way: if you have a data breach once because there's a vulnerability in your network, and a year later you have another breach and it's tied to that same vulnerability, you have not done your job to fix and learn and evolve as an organization. And that really is critical. Next slide.